Right to counsel, right to effective counsel, guaranteed by the United States Constitution when you are accused of a crime. Well, what does it consist of? What is effective use of counsel? Takes us to this week's case. Involves a real man, Alexander Roy. Alexander Roy was accused of child pornography. Interestingly enough, he was a teacher. The guy who was defending him, Jay Kirshner, was a fellow putting on a defense. But one day, when the trial went into session, Mr. Kirshner showed up 7 minutes late, 7 minutes late. And at the end of conclusion of the trial, at the end of the trial, the jury came away and said, Mr. Roy, you are guilty. Well, he wasn't happy. He wasn't happy. And he requested a new trial. Requested a new trial because he contended that his attorney, Jay Kirshner, did not provide him with effective counsel by virtue of the fact he showed up 7 minutes late when the court went into session one day. Well, the trial court heard this request and the trial court turned it down. So, Mr. Roy appealed that decision up to the 11th Circuit Court of Appeals. And at the 11th Circuit Court of Appeals, the court carefully heard the arguments. And basically the arguments were summarized as, one, on behalf of Mr. Roy, I was denied effective counsel because my counsel didn't show up and wasn't there for 7 minutes of the trial. On the other side was the argument that, well, hang on a second. This trial went on and the court was actually in session for over 31 hours. And basically the evidence is so very persuasive, demonstrating that he was guilty, that the 7 minutes isn't going to make a big difference here. More importantly, Mr. Kirshner came in, he immediately was up to speed, and he knew what he was doing. Based upon that, the 11th Circuit Court of Appeals came away saying, guess what? No new trial. No new trial because we do find that the evidence basically was overwhelmingly in favor of a guilty verdict. And in view of that, we think that the 7 minutes was de minimis. It really didn't make a big difference. And while an attorney being absent from the courtroom certainly is a denial of effective counsel, in this instance, that 7 minutes doesn't make a difference. Okay, now how does this differ from a case we talked about a couple of weeks ago, where we had an attorney who in a criminal case was falling asleep and he contended that it was his antihistamines that was making him drowsy. Okay, well in that instance the attorney was falling asleep on a routine basis. Every few minutes it seemed like he was nodding off a bit. And in this instance we had a guy who wasn't there for 7 minutes. In the case where the antihistamines were involved, the trial judge, granted a new trial. In this case, the appellate court did not grant a new trial. And what is the difference? Well, basically a difference exists in that the fellow who was unfortunately being afflicted by the antihistamines, there was really, unfortunately, not a real strong evidence that he was really on top of his game, that he was intermittently falling asleep, and how well he was attuned to what was going on was uncertain. And as to the degree in which it was uncertain was demonstrated by the trial judge. A trial judge who heard the motion for a new trial had observed him and obviously found he wasn't fully engaged and therefore granted a new trial. In this instance, we had a guy, Jay Kirshner, who showed up 7 minutes late. He apparently was on top of his game. He was able to provide very effective representation through the majority of the trial that, as I say, went on for over 31 hours with the court being in session. And as such, the appellate court came away saying, hey, you know, that wasn't a major indictment of his performance, and more importantly, the evidence was just overwhelming, and 7 minutes out of that trial isn't going to make a big difference, and accordingly did not grant a new trial. Okay, we bring you this case and we compare these two cases today so you understand how the law works. I'm David Allen.